Johnson, good morning.
Good morning, Your Honor. I have one thing to say before the timing starts. Normally, people get 15 minutes. I've been given 10. I'd like, therefore, and I was told because the court really thinks that's all that's needed. In other words, so I'm assuming that you don't have many questions. It's pretty cut and dry what has happened and what will happen. So what I want to do, if I might, is just please give my presentation. I've timed it to, it's roughly 5 minutes. And then there were about a half a dozen motions. I'm only addressing few, 1 or 2 lines literally per motion, and 2+ minutes, 2.x minutes for all 6 of them.
Well, you got 10 minutes, period.
Well, okay, so if you can
Use
hold
it
the
any way you
questions, if
want.
you have any after, that's period. And then I have, of course, the other case as well. And I'll do the same thing. So I'll just read through and stay right on point, and that won't waste any time. Thank you. Good morning. Your Honors, surprise me and reverse your predetermined judgment of disbarment. A few weeks after the 2002 gubernatorial election, I received notice that I would soon be served with a petition for discipline and was told that my criticism of judges interfered with the administration of justice. I concluded that proposed discipline was in retaliation for my running for governor on a platform of court reform and the abolishment of judicial immunity. During the next few years, my rights, even according to the rules this court wrote to govern process at the BBO, those rights were trampled. For those of you who are familiar with my website, as a result of the BBO's filing so much of it as part of the appendix, please go see Drano number 102, where I describe the process in detail. Although disbarment seemed inevitable, I naively held out hope that reason and justice would prevail. When you denied my motion last year to stay the disbarment in order to continue representing my existing clients, the only logical explanation was that this court had predetermined my disbarment, and that its goal was to discredit my reputation, and that goal outweighed its concern about my client's interests. So surprise me and reverse your predetermined judgment. Your agent, the Board of Bar Overseers, violated my First Amendment rights, my right to constitutional due process, my right to constitutional equal protection, my right to a fair and impartial trial. On your website, you declare that you control and supervise the Board of Bar Overseers and the Office of Bar Counsel. I therefore hold you responsible for violating my right to a public trial, a right expressly given me under the rules created by this very court. On the day of the scheduled public trial, the hearing officer ordered the public out of the room. Because the hearing officer had previously ordered the stenographer to go off the record when I spoke and back on when he spoke, I feared that the BBO could put false words into my mouth, and I'd have no proof that I didn't say them. So I left with the public. The so-called trial went on in my absence and in the absence of the public. The only persons present at the alleged so-called trial was a special hearing officer, an assistant general counsel, that was Carol Wagner, and the prosecutor, Ms. Weinberg. The prosecutor produced no witnesses, no supporting documents, only unauthenticated copies of my website files, which are written in HTML and can be changed at whim, but failed to identify where there was anything offending or unlawful in them. The prosecutor produced, in other words, no identification of anything. The prosecutor produced, in sum, no support, either factually or legally, for the accusations against me. In contrast, I had evidence, factual and legal support for my issues, but I was not allowed to present it. I was not allowed to have trial witnesses. All my trial witness subpoenas were quashed. They did that before I left the the trial room that day, not a court. I was not allowed to offer documents. Repeatedly before the trial, the BBO had ruled it was precluding me from offering documents in my defense. In sum, I was willfully prevented from preventing my defense to the BBO accusations. I was entitled to a fair and impartial trial. I did not get even what amounts to the appearance of a fair and impartial trial. I was the victim, clearly, of a kangaroo court, where there was no evidence brought forward to a public trial. There is no right to disbar me. Even after the sham trial, the very hostile hearing officer found that I had committed no fraud, no deceit, no misrepresentation to anyone or to any court, and that I owed no one any money. Ultimately, the single justice not only parroted that which the BBO wrote and did, actually Susan did, he also failed to follow the written practices and procedures for a single justice, which set out the grounds upon which Bar Counsel may petition the single justice for disciplinary action against any attorney. And that's on your website also. They include misuse of or loss of client funds, neglect of client interests, fraudulent conduct, sanction in another jurisdiction, conviction of a crime, and misrepresentation to the court. None of those grounds is in the disciplinary case against me. I appear to be the exception to the rule. But it is not only my right to criticize the judiciary when I see wrongdoing, it is my obligation to do so, particularly when the judiciary will not police itself. Disbarment will not accomplish what you hope it will. It will not keep me from using my knowledge, my spirit, and my speech to achieve court reform or the abolishment of judicial and quasi-judicial immunity and to address judicial inequities. Disbarment will only serve to wrongfully punish me for exercising my constitutional right to free political speech. So I can only hope that you will restore honor and integrity to this court by reviewing all the facts and concluding rightfully that a travesty of justice has occurred. Please surprise me, do your duty, and make a fair and impartial decision to reverse your predetermined judgment. Now, at this time, I just have 2 minutes more for those motions. And I say, Your Honors, there are, the first one is paper number 7 on your docket sheet.
Ms. Johnson, I don't think you're going to have enough time to read it all, and you have submitted very helpfully your written remarks.
But I know this is going to be webcast, and I'd like this part to be, because no one has decided the motions. I've never been allowed to argue them. So if I may include them, I would appreciate it for the webcast and the record.
You have 1 minute to
I
do
need
so.
2, Your Honor. My red light hasn't begun even to done. The paper number 7 arose out of the BBO's appendix, which was filed in the single justice session and has been accepted as the record in this court. The BBO did not give me copies of the appendix, and this court failed to act on my motion for you to order the BBO to give me a copy. If I or any other lawyer tried to file pleadings in a court or documents that had not been served on opposing counsel, I or any lawyer would not be allowed to file those documents. Therefore, having wrongly accepted them, the appendix, which I have not seen, those documents that they supplied should be stricken, with the exception of those which I supplied. The second paper, paper 12, I sought an order commanding the BBO to correct docket sheets for the BBO case, to provide me a table of contents for the 12 volumes of the appendix, and to provide me a copy of the appendix. I'm entitled to those 3 orders. If you do not reverse the judgment of disbarment, I shall indeed need those items should my intended petition for certiorari to the Supreme Court be granted.
Thank you, Ms. Johnson. Your
I
time
have 2
is
more.
up.
One other thing, if I may, Your Honor,
Ms.
please.
Johnson, with all due respect, we have time limitations in the court, and we would be happy to take your submissions.
I know, but I
under the
sat
time.
here all morning and I saw this blink for a long time while the men were speaking. One sentence, only one other motion will I deal with, okay? One other motion. Papers 20. I moved this court for a declaration as to what constitutes the unauthorized practice of law. As the court has stated, it is difficult to define the unauthorized practice of law. Given, however, that the statute carries a criminal punishment, it is mandatory that this court set out the elements before charging anyone, including myself, with the unauthorized practice of law. And I'll skip over to the other 2 motions and rely on what I wrote. But basically, I oppose all of the BBO's motions, which essentially are to impound everything I've ever written or filed in this court.
Thank you, Ms. Johnson.
Thank you, Your Honor.
Ms. Weisberg?
Sorry.
Good morning, Madam Chief Justice, Justices, and may it please the Court. I will not try in these few minutes to deconstruct the argument that has preceded me. I would like to remind the Court only that this is a bar discipline proceeding, and the issues in the bar discipline proceeding were, first, whether the respondent, Barbara Johnson, engaged in misconduct in violation of the rules of professional conduct or their predecessors, the canons of ethics. And second, if so, what sanction was properly imposed on Ms. Johnson. This case is about Ms. Johnson's misconduct as found by the board and as upheld by the single justice in the county court. I will submit only that the respondent has not shown any constitutional or other infirmity in the bar discipline process of the Commonwealth, as she baldly asserts, either on its face or as applied in this case to her, nor has she shown that any of the factual findings underlying the disbarment judgment are unsupported by substantial evidence, or that any conclusions as to the disciplinary rule violations are legally or otherwise erroneous. And finally, she has not even attempted to address or show that the disbarment imposed by the single justice is markedly disparate. Those are the issues before the court, and these have been extensively aired and briefed by Ms. Johnson and by Bar Counsel, and unless the court has any questions, I will submit on my brief.
Thank you, Ms. Weisberg.